Imagine you having this tenant that has strong head that you have been telling to leave your house and is refusing to leave your house. Or as a tenant, you paid for house, okay, you shall pay, but your rent are due. And landlord is saying you should go, but you did not go. The landlord now lock the door. You even change the lock safe. That's what we're going to be discussing on today's episode. Welcome to Education, the podcast that breaks down your civil rights and obligations for you. I'm Rachel, your host, and with me is Damilola.
Okay. Hi everybody, welcome to today's episode of Education. We have our barista in the house, our correct barista. Barista Timothy Adeyemi.
Thank you, Dami. Thank you, Rachel. You know, it's always very exciting being on the show with you. Thank you.
I'm always happy to have you too. We are.
On today's episode, we are going to be talking about eviction. Let me break it down. They pursue you from house. That's what we're going to be talking about today. And the processes that we need to follow. You know, there are processes and there are processes. Now, processes is for courts. Now, that's what we're going to be breaking down today. Sir, what are those processes that we need to follow?
This is your process. I don't understand. But then, yes, there is a process. Because the lack of following the process can mean trouble.
Okay.
So, number one, like we have said, under all the, what do we call it, the tenancy laws of the different states and all of that, there is a process which you must follow if you want to evict a tenant. Number one thing that is required is that you serve quick notice. Usually, the law, if it's a yearly tenant, for instance, the law, if there is no agreement, you will serve 6 months notice to quit. That is, what I mean by yearly tenant is when the tenant renews his rent every year. If there are no agreement that are breached that time, you serve 6 months notice. If it is a monthly tenant, for instance, you serve 30 days notice. If it is, what do we call it? Maybe if it is 6 months, if he renews his rent for 6 months, I think the law says you serve notice of 3 months and all of that. But all of these, what do we call it? Lengths can actually be a breach in your agreement. Even though the law says that 6 months, you can, by your agreement, state that the tenant is only entitled to 1 month notice. All right. If you have agreed on that in your agreement, then you should now serve that notice to the tenant before the expiration of the tenancy. All right. That's number one. That's quick notice. Number two is that you as a landlord, after the expiration of the quick notice, you now serve 7 days in owner's intention to recover possession. That is, you wait till that quick notice expires, the tenancy has expired, and then you now serve notice that I want to collect my property back. After the expiration of that 7 days, and the tenant refuses to leave the property or to vacate the property, deliver possession to you, now you can go to court. You go to court to ask the court for, I think it was last episode that we talked about the different remedies that order for possession, damages, arrears of rent, and all of that. So you now apply to the court, and then the court will now make all of those orders.
Okay, so you are saying that a landlord cannot ask for ownership of property to recover his property before serving the quick notice. Let me just collect the property, but you still pay my rent. Is that possible?
Let me just do what?
Let me collect my property first, but you still pay the rent. Cancel
without serving the notices.
Yes.
Now, this is what the law says, that, for instance, you can dispense with the quit notice and wait till the tenancy expires. Now, the law says that if your tenancy expires today, by tomorrow, you have become a tenant at will. And that means that you are only entitled to 7 days notice. I don't know if you understand it. Now, before the expiration of the tenancy, you have to serve quit notice. But if the tenant has not renewed his tenancy before the expiration, we call it that the tenancy has expired by exclusion of time. That is, he has run down his tenancy and that tenancy has expired. You understand? So you serve only 7 days notice in that situation. Whether or not you serve quit notice will not matter at that point. You understand? But without serving any of these notices or applying to court, you cannot just forcefully take your property and you cannot forcefully. You have to go through the process. In fact, let me add, like I said, that after you have served the notices, you have to now apply to the court. You know, the court requires, or the law requires that you prove to the court that you have served all of those notices. In paper Ogutola versus Papersack, the Supreme Court stated that those notices are important. But I want to quickly add now, in fact, the new law now, the new position of the law now, in Pillars Nigeria Limited versus Williams, the Supreme Court has stated that case lasted for about 28 years from the beginning to Supreme Court. The court has now said that, in fact, if quit notice was not served, owner's intention to recover possession is not served. As long as you have been served with the rates of the court, you have been served, let me use your language that you can understand, you have been served the court process. Once you have been served the court process, that court process will serve as a notice to you that the owner will want to collect his possession, especially when your tenancy has expired. You know, when I was reading through that case, it was a funny case. A tenant that has breached the agreement, the tenancy agreement, who has not paid tenancy and all of that, yet was just going from court to court, appeal, just to delay, I will still stay in this house and all of that. So the Supreme Court has, and the claim is that I was not properly served the required notice. The Supreme Court now says that situations where, like when you have not paid rent, for instance, and then you have been served the court process, that suffices, or that serves as enough or adequate notice to you as a tenant. So that's the current position of the law now.
So what can tenants do now if they are illegally evicted from their homes?
Yes, we discussed it earlier in the last episode. If there is unlawful eviction, you can actually apply to, you can sue the landlord. You can sue the landlord for illegal eviction, claim damages, or what, depending on, maybe your property was destroyed, you put your property under the lane, and you can ask for damages in such situations.
So, just in case you and your tenant have fought before, or you and your landlord you have fought, you have any issue in the past, your landlord do you anyhow, your tenants do you anyhow, tell us in the comment section. We will answer you. We will give you the possible and the most secure solution to your problem. Just let us in the comment section. Or what's your worst landlord tenant experience that you ever had? Just tell us, let us know. And don't forget to subscribe as usual and share this video and like it.
Thank you very much, Barrister Timothy, for joining us.
It's a pleasure for me.
Yeah.
It's been a pleasure for me joining you on this episode.
Thank you, sir. If you have not watched the second episode, what are you doing here? If you have not even watched the first one, what are you doing here? Oh, you have nothing yet. Go and watch the first one, then the second one, then you now come here.
Yes.
Thank you very much, guys, for having us. We're going to see you on our next episode. Bye-bye.
Bye.